What is the greatest completely legal loophole that you know about? Viewers Edition. Story 1. I ran across this accidentally about a decade ago. I did some computer setup work for a charity. They didn't have much money, so in lieu of payment, they gave me ownership of a few shares of the charity. The idea being that in a few years, after the charity had grown and become worth more, I could donate the shares back to the charity and take a tax deduction for the donation. I didn't really understand this at the time, but the charity owners and I trusted each other, so I agreed. A few years later, I donated the shares back to them. While preparing my taxes that year, something just seemed off. To understand, first you need to understand what a tax deduction is. When you get a tax deduction for X amount of dollars, the government is just saying that you don't owe income taxes on the X amount of dollars. So if you donate X dollars to a charity, you don't have to pay taxes on that. It's like you never earned that money, and instead it went straight from your employer to the charity, completely bypassing you for income tax purposes. Because of this, it's impossible to make money from a tax deduction. Since tax rates are always less than 100%, the amount you donate, money you gave away, always exceeds the reduction in your taxes, money you gained from not having to pay taxes. This wasn't happening. If I'd sold the shares for X dollars in cash, then I would have an income of X dollars that I would need to pay income taxes on. But by donating the X dollars in cash to the charity, I would get a tax deduction for that amount, and that would free me from having to pay income taxes on the amount, and thus my donation would be tax-free. But I'd still owe taxes on the rest of my income. But by donating the shares without selling them, I was getting a tax deduction for that amount, even though I never received that amount in income. So the deduction was reducing the rest of my income by X amount for the purpose of calculating my income taxes, resulting in me having to pay lower taxes than if I'd sold the shares and donated the money. That is, it allowed me to make money at the cost of the IRS via a tax deduction. Two seemingly identical transactions with very different tax consequences. I asked several CPAs and a tax attorney about this. They researched it, and all of them told me, as strange as it was, it's correct and 100% legal. The light bulb came on a few years later. Zuckerberg set up a charity that he controlled, then donated a bunch of shares of Facebook to the charity. That got him a big fat tax deduction for the value of his donated shares, hundreds of millions of dollars, even though he still owned the shares, just via his charity now. He didn't owe taxes on hundreds of millions of his regular income due to the tax deduction. Exactly what I had experienced times a million. This whole thing is a loophole inserted into our tax code to allow rich people to dodge taxes. It must still be in effect because Musk just did it. Story 2. Let me tell you the story of a man I fondly refer to as the GameStop millionaire. I was a manager for GameStop back when they started a program where you could buy Amazon gift cards as a print-off code in store. A customer figured out that he could go through Amazon's site to buy GameStop gift cards from the JetBlue portal, the airline, basically bought an Amazon card from GameStop once, then used it to buy a GameStop card online, then used that to buy another Amazon card from us, over and over, racking up free airline miles. After a couple of visits, we convinced him to get a PowerUp Rewards card. This gave him rewards points from GameStop with every purchase on top of all that. Points that could be cashed in for $off coupons for GameStop. He quickly raised the amounts involved and even got his wife doing it as well, collectively gaining over 1 million rewards points. We did some rough math, and he could have bought every collectible in the store without paying a dime out of pocket. He literally did most of his Christmas shopping with us that year. This is where the exploit was discovered, and we were told by corporate to kindly request he stop the process. But at the time, no rules were being broken, so they couldn't outright stop him. Eventually, they did freeze his rewards account from collecting more points, citing some vague rule, most likely new, about abusing the point system. He still had access to his existing rewards last I was aware of, and shortly after, the Amazon card program was shut down. Story 3. For the timestamp 2850, yes and no. First, do not drag them anywhere at all. You're just tampering with a crime scene that wasn't a crime scene until you did that. And in any state, the only time you can end the life of another person is when you are completely 100% positive that if you don't end their lives, then they will 100% end yours if you don't. Or if it's in the case of a kidnapping or red rum of a third party, and shooting them is the only option to stop this. And shooting them with intent to just injure them is not a legal action in any U.S. state to stop them from ending your life. The part where ending their life comes in is when they say you start shooting and take their hand off and they're unarmed. Well, if you stop shooting, they could sue you, so you should follow the training you never had and stay terrified that they're still a deadly threat and keep shooting. So what happened was he pulled a gun on me and I knew my life was over, but I had to try and maybe I could survive getting shot, so I started shooting back and fired until my gun was empty. Warning, you are responsible for everything you shoot. And I'm not really sure what the frick happened, and I don't know if I'm alive or unalive right now, and just having the part of unaliveness where your life flashes before your eyes. So, officer, if I'm alive, I don't know how it's possible. You should have a story like this, and it needs to be true. This is not legal advice and is meant to show that ending the life of a person on your porch and dragging them inside is red rum. Story 4. To the Walmart comment, first to know is that neither the state nor the police makes the rules for roadways. That would be the Department of Motor Vehicles. Also taking note of what capacity the police are in. If they're in the public capacity, then they can't enforce anything on private property. Doesn't matter what contract law they have made unless you agree to them. This is all states. Side note, just remember symbolism is very much a thing in the USA and words do not mean what you think they mean in Black's Law definition. Example, when a judge cites a contract law, then says the punishment, before asking, do you understand? What he did was say a verbal contract and asked, do you stand under my rule? Do you understand? That is why they are on a podium above you. Also, unless you fully understand what I'm talking about, don't you? You're gonna get thrown through the ringer. A great example in Michigan is 257.42, which is what police can do for public roads, in which it says only 257.255 and 257.215 can only be enforced with respect to commercial drivers. Unless driving for fiscal gain, you don't need insurance, plate, tag note, just a title with proof of no lien, which falls under 257.49a. A recreational vehicle, been arrested 6 times and released each time. Granted, even though I'm correct, I've had to sit in jail, lose jobs, etc. for knowing the actual laws granted. I'm not wasting money each month on insurance. Got the cops trained on this after 5 years, but still was a headache prior to getting there. Story 5. My favorite pizza place closed down shortly after the following story occurred. It was like a Subway where you could just pick the kind of crust you wanted, only one size, one price, but different crusts. Then, like the Subway, you went down the line requesting as many ingredients as you wanted at no extra cost. My favorite was half pizza and salad, where they made the salad the same way, so it can be a huge meal by the end of the line. A big salad. But that's not the coolest part. They had a tap wall where you exchanged your valid ID for a bracelet that would operate the tap wall where you could pour up to 32 ounces before you would need to request a refill. That way they can assess if you should continue being served alcohol. I really enjoyed pouring myself tiny samples of just about everything they had, almost 24 different taps. My favorite was a red chili hard apple cider, but for some reason that tap kept failing to charge. I dropped in 2 or 3 times each week and notified them on 3 separate occasions over the course of about 6 weeks that their tap was not charging. But they never did anything about it, other than the first time when they put an out-of-order sign on it for the rest of the day, but never again. And 2 months later, they were suddenly out of business. I'm not sure if that was the cause, but I literally sat there and watched dollars being poured down the drain for 6 weeks. I'm so bummed they're gone. They had the best anchovies I've ever had. Story 6. On Story 35, for Texas, that only works for break-ins in the actual home, and on the first instance of it happening on record. A few years ago, we got caught in a funny situation where the same group of people kept stealing parts off our vehicles in our driveway. Wasn't in the house, and after the first 911 call, police report, any attempts to trap the vehicle or stake out and wait for them would fall under premeditated, and dismantling the parts we knew they wanted and leaving it out for them was considered an attractive nuisance, which you get a fine for. All we were told we could do by the police was call if we heard them out there and wait for them to show up. But of course, by then they were always gone. Engaging with them was considered vigilantism. It took 19 visits from them and multiple sawed-off and stolen pieces of our cars before we finally caught them and it stopped. I saw a story similar to this on a true crime show that took place in an actual home. The same 2 people kept breaking in. The police wouldn't do anything. The guy staked me out with a gun and shot them both unalive next time they broke in. They got convicted for red rum. Wild stuff. Story 7. Britt here. The guy with the castle was out of order, and very simplified, I'll explain why. Planning permission exists to protect people from the nearby construction of buildings that decrease the value, enjoyment, privacy, etc. of their home. The time limit on complaints exists to protect owners of structures from vexatious litigation. For example, I buy a property at a lower price because it's near to a construction, then try to get it removed to increase the value of my property. He exploited legislation that is there to protect people, but it's worse. He did it on protected green belt land. Allowing him to keep it would have destroyed the various protections in place and opened the door to all kinds of exploitation and harm. He went through lengthy legal appeals, lying his head off throughout, and spouting his entitlement until he eventually deconstructed it after being told the alternative was prison, and it would still need to be removed. He had to pay all the costs. Personally, I think they might have done better to just prosecute him for criminal damage to Greenbelt land and promptly bulldozed it. He obviously knew it was an illegal structure, but rich people getting away with things is nothing new. Story 8. Story 24. In the UK, we have what are called permitted development for properties, which allow some modifications without the need for planning permission, such as some extensions and attic conversions, etc., all listed on an easy-to-access and read website. Unfortunately, the guy building the house in the haystack actually broke the law as part of the 4-year rule, and was that the development building had to be built where it could be seen, and if no one objected to the development or building in the 4-year time span, then it could be given retroactive planning permission. As he hid it from view, this meant that the rule did not apply, and the building has since been demolished under court order. Another aspect that broke the law was that you cannot put or modify crenulation, top of castle wall humps, on a building without the Crown Estate permission. This rule is to protect certain buildings which may already have them from being altered. My qualifications are in building studies and BSc in property and asset management, and my work was in interoperating the rules and making modifications to buildings based on the rules. Story 9. You can report them as income, however their value is subjective. Say the charity gave you 1,000 shares of their charity for your services. Okay, well, how much is each share worth? You can make that part up because it's subjective. Have the charity claim the market value of each share is worth 1 cent. That means you received 1,000 shares for a total of $10. Then wait however long you want and donate the shares back to the charity when you need to. But now you have the charity claim the market value of each share is $100. You just donated $100,000 to charity, and you get to write off $100,000 from your taxes that year, all the while previously recognizing the shares as $10 of income. Legal tax manipulation, aka legal tax fraud. And the cherry on top is that you get to subtract the $100,000 from the bottom line, tax owed, of your tax form, not the top line, your income. Boom. Story 10. Unfortunately, it's another English guy. Unfortunately, here in the UK, there are stipulations in the building regulations that state a house must be in fitting with the surrounding area. For instance, if you have cottages around you, you can only build in that style of building, and it must also be of similar size to the housing in the area. Also, the building itself needs to be visible for 4 years, once built, not hidden behind hay bales, like was stated in this video, and was also around 5 to 6 times the size for the area. It also requires several visitations from health and safety to make sure the building is up to standards throughout the builds, inside and out. This is why he lost the court case and was told to tear it down as he tried to get around it, saying it was an agricultural building when in the planning stage initially, and was turned down at the planning stage and went on to build it in secret anyway. Kind of a hybrid of English and New Zealand. We'll keep on working on it. Story 11. That wouldn't be the case though. It's a service that would be under a EULA. In such, EULA, a EULA, they have a we can change this anytime, either with warning or without warning, which falls under other laws on which they're allowed to do for this particular EULA. And said warning could simply be a mass email sent out to all registered email addresses, so might have received it anyways. Not GameStop's fault if you don't read your emails. While these changes wouldn't be backward compatible, arguably, they would be applicable on anything after said changes came into effect. So no, you can't sue them for changing the rules. Good luck finding a lawyer to take this on, and even more luck getting more money back than it would take to sue them, even if you did win, as generally lawsuits over contract disputes are not awarded legal costs to the loser. Overall, a very bad idea. Story 12. I work security in a private property that's open to the public. Here's what I know. The speed limits posted are a suggestion. Stop signs, suggestions. General traffic laws, again, suggestions. You can drive the wrong way or across the parking lots, etc. It's annoying, but no one can do anything about it legally. This means that cops will not enforce any general traffic laws as long as you're inside the property parking area. If an accident takes place inside the parking lot, cops will normally not even come to mediate it. Sometimes they do. They don't give out tickets for any infractions, even if it's clear someone broke a general traffic law because it's private property. In general, it's preferred you abide by the signs posted, as far as traffic is concerned, for your benefit and for others as well. Don't be a butthead, because you never know who's driving around you. As perfectly demonstrated by the A24 show, Beef, now available on Netflix. Story 13. This current Supreme Court, with Trump's 3 appointees who lied about what they'd do if faced with a Roe v. Wade adjacent case, doesn't grasp separation between church and state. They presume to order Maine's education department to allow religious private schools to participate in the school choice voucher program, forcing taxpayers to subsidize religious education. So Maine changed the verbiage of the legislative language to continue to exclude Christian schools. It used to be, in oversimplified terms, no Christian schools may receive tax-funded vouchers. Now, again, in simple terminology, it's schools which do not address the needs of LGBT students and schools which do not offer employment opportunities to LGBT applicants may receive tax-funded vouchers. Nobody can force taxpayers to subsidize entities which discriminate against protected classes based on sexual orientation or religion. For a Christian school to become eligible to participate in Maine's school choice program, they would have to hire gays and atheists. Story 14. Here, the building and zoning inspectors in a municipality pretty much have free rein to tell you what you can and can't do with your property. You can't even own more than a couple older cars that are generally considered ugly or unpopular and drive them regularly in the US without having your municipality come around trying to slap tow tags on registered, insured vehicles. My municipality actually has a vehicle per occupancy permit limit of 3 cars and 1 more car per licensed resident. This was adopted in 2002. 4 years after we bought our home here. I have heard conflicting ideas about whether I'm grandfathered in or not. It does not specify the inside or outside of a garage. Is this unconstitutional? I know it's not freedom. I have yet to find a lawyer that specializes in protecting automobile collectors. All this over a few rusty K-cars. Crusty cray crabs. Story 15. For Story 34, the OP is saying that if he and the other person wants to play the same game at the same time on their 2 Xbox consoles, they buy it once rather than twice. And yes, it will be digitally. Xbox allows you to play any game you own on your own account, regardless of whose Xbox it is. But also any account on your home Xbox can play any game you own too. So person 1 buys the game, but the Xbox belonging to person 2 is set as his Xbox. Person 1 can play it on his Xbox because he owns the game, and his account can play its own games anywhere. Person 2 can play it because his Xbox is considered to Microsoft as the home Xbox, so any account can play a game owned by the home Xbox of the account that owns the game. Story 16. Quite a few years ago, I used to have a prepaid mobile phone, and making calls was rather expensive. The service provider, Vodafone, had for years run a free Vodafone to Vodafone phone calls promotion. So I got to thinking one day that maybe I could set my phone to divert all voice calls, when busy, to the number of the person I wanted to call, then call my mobile from my mobile, and because I was calling my own phone, the line would be busy and the call would be diverted to the number I actually wanted to call. And because I called my own phone, the call tricked the system into thinking that it was a Vodafone to Vodafone call, and the call was then free. I did this for years, only paying for the minimum monthly recharge, which was $5 buckaroonies back then. Story 17. This is a very common loophole. However, the refund normally would only happen, which covers the self-employment tax cost, and still has a refund if the person can also claim their children, which would increase the amount of the earned income credit, with the exception of the pandemic years 2020 and 2021. Everyone qualifies for those 2 years as well. Also, you say hobby, but there's also jobs like childcare, where most people take house cleaners and such for granted. Those are actually considered jobs and would be considered self-employment. The other side would be losing money while trying to start your own business might be considered a loss against your normal W-2 paying job. Story 18. This refers to the hobby loss rule. You can take a loss on your small business for a time, but if audited, you need to show an intent to profit. Also, there is generally a 5-year limit before the IRS makes you prove more diligently that you can make the business profitable, or they call it a hobby, and you no longer write off losses, except as a direct offset of cost to a zero limit. That is, no loss, just break even. If that hobby does make a profit, you then must file taxes on said income, including the referenced self-employment taxes. Keep all receipts and good records. Also, the IRS is aware of the idea of an Escalade as a farm equipment scam and will rain on your parade. Story 19. When I was in high school, our tardy system was also broken. I would purposely be 10 to 15 minutes late. Missing the bus was my excuse, so I had to be sent to the office for a tardy slip. But eventually I just went straight to the office. Well, if the office gave me a tardy slip, if the teacher marked me absent, the office tardy would override it. I would get the tardy slip and go to the library or something else. My senior year, I had only one block some days, so I would use this trick and just go home right after. Midway through senior year, I found out it no longer worked when they called my parents for an unexcused absence. Please leave your stories in the comments. I'd love to make a video of them in the future. Also, don't forget to like and subscribe.